Let's all stand.
Yes, Mr. Stewart.
Can we have paragraph 42 of BCG's statement on the screen? So you see, Mr. Bardich, this is what BCG says. She says she remembers meeting with the elders, that's you and Mr. DeRoy and Mr. Ally, by herself on a number of occasions for a couple of hours at a time. On one occasion, you brought her father into the room so that she could tell him what she had told the elders. She cannot recall exactly how many times she had to meet with the elders. She didn't want to be there. She felt so uncomfortable. And she says, I had nobody to support me. I don't remember anyone really explaining the purpose of the committee meetings to me, but I understood at the time that the elders were investigating what I had alleged. And then if we look over the next page, perhaps you can read 43 to yourself. And then you see in 44, she says, because the elders were all male and all were friends of my father's, I was reluctant to speak to them about what had happened. Unless they asked me a direct question, I didn't really offer the full detail of the sexual abuse. So you'll appreciate that the constraints that BCG felt under about being able to speak freely.
Yeah, I can understand that.
And I think in your statement, you recognise that in the sense that you say the story came out in bits over time. Is that right?
Yes.
Yes. And do you appreciate or do you accept that it's not a process, I withdraw that, a process where the victim has to put her allegations to the accused in front of a number of men is not one that's conducive to arriving at the full story?
I can understand that, and I felt for her then, and I'm still feeling for her now.
It's not a good process, is it?
Could be better.
Yes.
I think that's what we're all trying to arrive at here, is processes that are better for ones that are victims.
So if we might identify the respects in which it might be made better. Firstly, that a person raising sexual abuse allegations have someone with her to support her if she should want it. That would be an improvement, wouldn't it?
Yes.
And that she not be required to put those allegations in the presence of her alleged abuser. That
Yes.
Yes. And that she not be required to put it to a committee of 3 men. That would improve it, wouldn't it?
Sorry.
That would improve the process, wouldn't it?
Yes, the committee of 3 has got a purpose, because every one of us will hear different things, and it's to make sure that we get to the truth as much as we can.
Well, what BCG is really saying here is she felt unable to tell the whole truth, in part because she was having to say these intimate things to 3 elders who were friends of her father. That was hard for her.
At that time, We thought that he was a disgusting man. We believed her 100%. And we just wanted to see him out of the congregation.
Mr. Bowditch, that's not the point of the question.
Oh, sorry.
The point of the question is that the process that you engaged in required this young woman to disclose intimate details about what her father did to her sexually to 3 men, each of whom was a friend of her father. Now, do you not understand the difficulty that a young woman would have disclosing personal sexual details to 3 men?
Yes, I understand that, Your
Is it
Honour.
appropriate that your processes require that to happen?
I understand that, Your Honour.
Is it appropriate?
Is it appropriate? Probably could be a better way of doing it.
What's the better way?
I am unsure of that.
When you do understand, I assume, how difficult it would be for a young woman to speak in those circumstances.
Yes, Your Honour.
Can we look at paragraph 5.1 of your statement? That's at page 0004 on Ringtail.
Sorry, what was the number again?
Page 5. Paragraph, I beg your pardon, 5.1 of your statement.
Yes.
You'll see under the heading, the decision of the elders in the Mariba congregation to disfellowship BCH in 1989 and the reasons for that decision. And you say the decision to disfellowship was based on his immoral relationship with another woman and leaving his wife and family, and his lying about this to the elders. I recall also that we felt the sexual abuse had been established. The appeal committee confirmed the decision to disfellowship, and both committees found that he was unrepentant. Now, in fact, you did accept, in the sense you believe BCG's allegations about her father, didn't you?
Can you repeat that, sorry?
You personally, you believed what BCG told you about her father?
I believed it right from the start.
And is it right that her father admitted those allegations in the presence of the committee eventually?
In the presence of the appeals committee.
Yes, well, you say that in a paragraph I'll come to in a moment, but dealing first with the Judicial Committee, did he not admit it in the presence of the Judicial Committee?
Not to my recollection, no.
Take a look at tab 3 of the tender bundle. Perhaps we can scroll down and show you the foot of that page as well, the end of the document. It's just a one-page document. Do you see it has your name, and I take it that's your signature, is it?
Yes, my signature's on top there.
Yes, and this is the report of the Judicial Committee back to the branch office on the disfellowshipping of BCH, is that right?
Yes.
When last did you have the opportunity to look at this document, Mr. Bowditch?
Probably 26 years ago.
You haven't seen it in the last few days or few weeks?
No.
Right, let's scroll to the top. I'd like you just to read it to yourself, and at the end of it, see if you agree that there's nothing in there about BCG's allegations about her father.
No.
Yes. Now, what by which I mean what did the Judicial Committee decide with regard to BCG's allegations?
With putting it in this document,
Well, it's not in the document, so
No.
I'm asking you, what conclusion did you reach with regard to the allegations that BCG made and which you investigated?
we believed BCG from the very start. We never believed BCH, I think it is.
Her father,
Yes.
yes.
We never ever believed him, and that's why we pushed, if you want, that's why we tried so hard to get him removed from the congregation.
And you removed him on these grounds of loose conduct and lying
Yes.
related to his relationship with another woman.
And also that lying, I'm not real sure now because I cannot remember the total details of that, but I think that lying would have come in with the allegations
Well,
about BCG.
on the scales on which you deal with these things, how do you compare the seriousness of sexual abuse allegations and, on the one hand, compared with pursuit of an adulterous relationship on the other?
My personal opinion right now is I would consider that any abuse is going to affect the person. Just trying to think of a better word.
Well, it's far more serious, isn't it?
Yeah, oh yeah.
It's a criminal offence to start with. Sexual abuse, child
Yes.
sexual abuse is a
Yes.
criminal offence. Yes. And back then, in 1989, you would have had that same view, I take it. You would have regarded
With a passion.
sexual abuse of a daughter by a father, firstly, very seriously,
I've got a daughter of my own around the same age. So yes,
and more seriously than the pursuit of an adulterous relationship by someone.
personally, that is my opinion. The Bible would state it as bad as, if not worse.
And in reaching a decision, you and your colleagues on the Judicial Committee, I suppose, were applying the Bible standards, were you?
Can I just have that again, please?
In reaching a decision on the Judicial Committee on these matters that were before you, were you applying the Bible's standards as to the respective seriousness of the two different sets of allegations?
We were applying the Bible standards at that
Yes.
time.
In other words, you were regarding the sexual abuse allegations as being of the same degree of seriousness, or perhaps less than, the allegations of the adulterous relationship.
Definitely not.
Well, if that's so, how do you explain that this report doesn't mention anything about the sexual abuse allegations?
I'm unsure on that.
And at that stage, in other words, when you reached your decision, you also knew, did you not, that the elder daughter had said that she had also been abused by her father?
I can't remember that at that stage. I'm not, I'm not trying to skirt around it.
So it may have been like that.
I'm unsure.
And that the mother had reported that the two younger daughters, who at this time, 1989, were still quite young, had also been abused by the father.
Don't remember that.
Was the problem for you here that you somehow regarded the two-witness rule as applying, and you didn't have a second witness of the actual events?
That wasn't the case.
Well, what would appear to be the case is that you didn't uphold the sexual abuse allegations. Are you able to explain why not? Why is there not a finding recorded here by your judicial committee that BCG had been abused by her father?
I'm unsure, but I would rather guess, because he was not admitting to it at that time, but I am unsure.
You say that's a guess.
Beg your pardon?
You say that is a guess. You guess.
I'm not saying for sure, yes.
Yes. No more questions, Your Honour.
You say, although it may have been that he wasn't admitting to it at the time, you've said a number of times now that you always believed BCG.
Yes.
Why wasn't that enough to found a decision to disfellowship?
On those grounds, I am unsure, and I don't know why we didn't put that in there. But at the same time, he was being disfellowshipped.
Yes, but you understand that for BCG, the trauma of having been abused and then the traumatic experience of being interviewed by the three of you, having to confront her father, and then the decision that you make, paying no regard as recorded to what she went through and the process of your committee. Do you understand that in itself
Yes.
was an extraordinarily negative thing for her to receive?
I can understand that, yes.
Well, can you give me any explanation as to why you let that happen?
Yes, Your Honour. Yes, thank you, Mr Burridge. My name is Ms David and I represent BCG this hearing.
Sorry, I'm having trouble.
My name is David and I...
Maybe just move that microphone so your
Sorry.
voice
Yeah.
captures his
Thank you, sorry.
my name is David and I'm representing BCG at this hearing. And I just have a few questions for
Thank
you.
you. Thank you.
Just on the point of, because the allegation was not substantiated under your judicial committee proceeding, do you agree that therefore it was not known within the congregation that in fact that BCH had been what was known to have actually abused his daughter sexually?
That would...
Well, it was not...
Yeah, just clarify that a little bit and I will give you the truthful answer.
If you look at, if you go to your statement, if you please go to your statement,
What page?
8.1, and that's number, it's 8.1.
8 point.
Do you agree that you've stated in your evidence that the reasons for BCH's disfellowship, as we've established, had nothing to do with the allegations from BCG?
So what it's saying that I can't even see how that would have come up. And I'm not trying to be evasive either. I'm just trying to work with you. There's usually about 7 days between a judicial committee and appeals committee. That appeals committee, I believe, upheld the decision of the judicial committee, and also, and that is where he admitted in front of the appeals committee of the molestation, and so that would have been added at that time.
But that information is not ever released within the congregation, is it?
No.
No. And so, therefore, do you agree that the process, by keeping it in-house, and your processes do not enable a measure of protection to be put in place to protect people from the likes of BCH?
The protection was he was, if you're talking about that particular case, he was no longer in the congregation.
But he went to another congregation, didn't he?
Yes.
And that information wasn't passed on, was it?
I don't know, because I wasn't there at that time.
So he was left out there in the community, wasn't he?
Yes.
And just coming back to BCG, you did take her in at some point, didn't you?
Yes.
You looked after her. I want to suggest to you it was quite close to the wedding. In fact, no more than a couple of weeks before the wedding that she actually moved in with you and your family.
I wouldn't have any idea.
Right.
I tried to work that out, but
and that before that, you did assist with her, and you were helpful in organising for her to stay with another family, the Grigors.
Yes.
Yeah. But that wasn't immediate, was it? I want to suggest to you that it wasn't immediate after the committee meetings. It was actually some months before any measure was put in place to put her in a housing situation that protected her.
I'm unsure of that now.
Yes. And so, because what I'm suggesting to you, that there was, for some months, she was exposed to her father coming back into the house that she had been living in with her mother and the rest of her family?
I have no recollection of that because my recollection is the father moved away
Well,
pretty well straight away.
you were aware from your knowledge within the community that there was there were attempts at reconciliation between BCH, the BCG's mother and father, and that he returned to the community on a number of occasions?
No. I've got no recollection of it anyway.
But you're not disagreeing that it couldn't have happened?
Beg your pardon?
You are not disagreeing that it happened, though,
No, I'm not
are you?
disagreeing.
No.
I really just don't know. No. Sorry.
So, in reality, she was very exposed, wasn't she, BCG, to a man that you observed to be quite violent, even in a aggressive sort of a man who was quite. You observed him to have a violent nature even within the committee process, didn't you?
Yes, in the committee process. That's why we told him to back off.
Yeah. So, but you had some measure of control within that process, because there was a number of men there that may have been able to protect her. You agree with that?
Yes.
But outside of that committee process, there was no such protection afforded her, was there?
I know she's BCG stayed with at least one other family, but I thought there was other families as well. But I can't confirm that.
In this particular case, given that you are dealing with a man who you've described as disgusting, and a man that you knew to had a violent predisposition from your own observations, wouldn't that have been the very particular case that you might have thought would be appropriate to send to the police? To notify the police to ensure that BCG was protected?
I agree with that, but at the same time, there were discussions about that very point with BCG, and you've got to realise, maybe if I explain the situation to you, can I do that?
Yes.
Here you have a gracious young lady who was about to get married to a young man, and she wanted to get on with her life. Okay? And I guess for that reason, even though that was spoken about with her, and she spoke about it with me, going to the police, we said that was a decision, I said that was a decision that she would have to make herself.
Isn't it a decision that she was actively dissuaded from doing?
Sorry, I didn't...
Isn't it her going to the police, she was dissuaded from going to the police by you and other elders, wasn't she?
Never by me, never.
But you're not aware of other elders. But wouldn't you think that by going to the police or some other organisation, that they would be sensitive to this, as you describe, her gracious young lady, sensitive to her needs and deal with it appropriately to protect her?
That could be the case.
Were you aware of her suicide attempts?
No.
That you had no involvement in
No.
that? Did you take any steps to ensure that she had proper counselling to deal with the distress of her experience at being abused?
You mean outside involvement?
Well, firstly, outside involvement, yes, outside of the congregation.
Did I personally take her somewhere?
Did you take any steps to encourage her to seek counselling outside the congregation?
I can't remember if I did or not, but it would be something that I would normally do.
That you
Is
would
there any inhibition on a member of the Jehovah's Witness seeking professional counselling from someone who is not a Jehovah's Witness?
No.
Is there any inhibition on you as a member or an elder encouraging someone to go to outside professional help?
No. I can... Just got to be careful how I say this. But there are people in the congregation who have got outside help, and it is even encouraged in our magazines. One this year for that sort of thing.
You said, I think, before that you would normally do something like that. Have you ever done that in a situation where you have been faced with a person who has made an allegation of sexual abuse?
Not an allegation of sexual abuse have I encouraged somebody, but I have on other matters.
I just want to ask you, just briefly, it is within the practice within the congregation, isn't it, that a child must be obedient to her father?
There's limitations on that.
But that is the rule, isn't it?
There are limitations on that. You know, that's not for everything. Like if the father told her to steal a lolly out of a shop. I know this is different, but it just brings up something. That child is not to be obedient to their parents. There's a higher. Does that make sense?
So, but it would be the person primarily responsible for the disciplining of a child is clearly the father in the family, isn't it?
Parents.
But in particular, in the Jehovah's Witness faith, it is the father.
The father has a responsibility, but the parents work with that together.
But you would expect, wouldn't you? Is it not that you would expect if there was if a young woman had something to say about her father, that you would expect her to go and talk that out with her father, wouldn't you? As in this case, at BCG, what I'm suggesting to you, that in fact BCG, you at the time expected that BCG confront her father and speak to her father about all the allegations.
No, I didn't expect that.
And that no one would listen to her in the absence of her being confronted by her father within a very short period of time.
I understand the first part of that, but I just don't understand the second part.
Well, the committee process involved the accuser facing the person she's accusing, didn't it? And that's what you would expect. That's what your faith expects, isn't it, of a young woman, that she must confront the accuser.
She doesn't have to, and particularly now, because this is changing, right?
Yes. But at the time that was the case, and that was that was how the procedures occurred.
And as much as anything, that was for a healing process, and I think even the law of the land understood that at the time. It was for a healing process, so she could get it out and tell the person that that had carried out this vile act against them.
But the healing process would also involve, would it not, the receipt of an apology? Wouldn't it?
There was
An apology is a big part of a healing process.
Oh, yes, I agree with that.
And that never occurred, did it, throughout that committee process?
No.
And it never occurred at any time, did it?
No.
And she was never told, was she, at any time that, in fact, the committee believed her 100%?
I told her.
I'm suggesting that neither you nor anyone else ever told her that she was believed.
I told her.
And I'm suggesting that, in fact, that all she was told was that because of the manner in which you needed to prove an allegation with at least two additional statements or eyewitnesses, that then you were not able to take the matter further.
I've never said that.
No, I'm saying that was your procedure at the time, wasn't it? That you needed the additional witnesses. You believed that you needed to have two statements at least to corroborate what she had said.
Two people? What are you saying there? You know.
What I'm suggesting to you, that the only thing that she was told was that because there were no witnesses to corroborate what she had said, that you couldn't take any action in relation to the abuse upon her.
We were taking action.
But not in relation to her abuse, you were taking action in relation to those other matters.
And that as well.
Did you arrange for her to have any sister from the congregation or someone to give her, to assist her and support her through this process?
There was a number of sisters in the congregation that supported her.
She was never referred to any of the sisters.
Quite well. Not as well as my own children, but quite well.
Was she a friend of your children back then?
Yes.
Back in 1989, BCG was engaged.
Beg your pardon?
BCG was engaged back in 1989.
Yes.
Did you know her fiancé?
Yes.
How well did you know him?
Probably not as well as BCG, but I knew him well.
Okay. Did BCG's fiancé have anything to do with supporting her during the Judicial Committee and Appeal Committee process?
He was there with her at one period, not in the actual room, but he was there at the Kingdom Hall.
Okay. The Appeal Committee was in July 1989, and you've given evidence that you tried to support BCG after that time. Is that correct?
Yes.
How did you do that?
In a number of ways. This was done by, first of all, the sisters, or some of the sisters in the congregation, were told that she needed support. tried to find
I'll just
who.
stop you there. Who were they? Who got any names?
Yes, I can tell you some. Am I allowed to say their name?
Perhaps you can just write them down.
Okay.
Please. Is the process then to tender that document?
Well, you can have a look at it and see what
Yes.
you want to do with it.
Yes.
I mean, I'm not sure for our purposes we need the names at all.
Oh, okay. Well,
But if you've got a different purpose, I don't
no,
know.
I don't. We move on from that. Aside from the sisters, what else did you do?
I did that, yes.
If I could just show you two documents. And then I intend to tender these documents, and my friend has copies of them and has seen them. I've got. Oh, you could show those, thanks.
Thank you.
And Your Honour will see that they're photographs, and we'll ask for a non-publication order in relation to them because there's no need for identify people. We'll prepare an order in due course, Your Honour.
Well, the purpose is to demonstrate that Mr. Ali,
Mr. Bowditch.
Mr. Bowditch gave BCG away.
And was supporting her in November 1989.
Is November 1989 the wedding time? Is it?
Yes.
Well, we know that already.
Yes.
Do we need photographs?
I was going. We need the second one.
I'm sorry?
Thank
Well, there's two photographs that are clearly wedding photographs.
Yes. Yes.
I don't think we need those.
Okay. No, I concede that, Your Honour.
I'll hand them back.
Thank you. Mr. Bowditch, you did give BCG away at the wedding.
Yes,
You used your vehicle as the wedding vehicle.
yes, yes.
Yes. Did your wife assist at all in relation to the wedding?
Yes, my wife is a seamstress,
Yes.
and I do believe she made the dresses for the two young girls.
Yes.
We were also involved in the planning for that. The congregation, along with the family, our family, provided much of the food for that, and any other support, entertainment, that was provided by the congregation as well. So there was support all around.
Thank you. Did you assist BCG and her husband after the wedding as far as somewhere to live?
Yes, we did. I can't say whether it was straight after or not, but they were given the use of the flat at the back of the Kingdom Hall,
Yes.
which is a little bit unusual because that's usually reserved for one of the elders, ministers, or a retired missionary, but it was given to them so that they could use.
And how long did they live there?
A couple of years, I think.
Thank you.
I have nothing further, Your Honour.
Mr. Stewart, I think BCG just wants to.
I could just raise one matter. Thank you, Your Honour. Just in relation to the supply of the house, the BCG and her husband actually paid for that as
Yes.
anybody else would, wasn't it? It wasn't given to her at all, was it?
No, it wasn't. They paid rent there.
Yes, yes. So they rented it. It was
Yes.
rental accommodation
Yes.
for which they paid. Thank you.
I have nothing further for Mr. Bardich, Your Honour.
Yes, thank you, Mr. Bowditch. That concludes your evidence. You're excused.
Thank you.
Your Honour, the next witness is Mr. Jason Davies. He used to give evidence via video link from Queensland, and I'm advised that those who handle the technology is that they need just a couple of minutes to make it work.
You want us to
And
adjourn?
if we might have an adjournment just for a short period of time.
We'll take a brief adjournment. Let us know when you're ready.
Thank you very much.
Let's all stand.
Your Honour, Mr. Jason Davies, wearing the purple tie, is on the screen, and he's accompanied by a legal representative who would announce himself. To Your Honour.
Good afternoon, may it please the Royal Commission. My name is Macmillan, spelled MCMILLAN, initials BI. I'm a barrister instructed by the Crown Law Office of Queensland. I appear for the State of Queensland and Mr. Jason Davies. I understand the State of Queensland has been granted leave to appear in this case study.
That's so. So you have leave to appear.
Thank you, Your Honour.
It's Mr. Davies, is it?
Yes, Your Honour.
You'll need to be sworn. Have you got a Bible, or do you want to take an affirmation?
Affirmation, please.
Yes. Would you stand for me if you could? And just repeat after me. I do solemnly, sincerely and truly
I do solemnly, sincerely and truly
declare and affirm
declare and affirm
that the evidence I shall give in this Royal Commission
that the evidence I shall give in this Royal Commission
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Yes, thank you. Take a seat. Yes, Mr. Stewart.
As Your Honour pleases. Mr. Davies, would you state your full names for the record, please?
Jason Peter Davies.
And Mr. Davies, do you have with you two statements by you provided to the Royal Commission, one dated 8 July 2015 and the other dated 20 July 2015?
I have my two statements, yes.
Is there any respect in which you would like to correct or amend the statements?
No,
Do you confirm them to be true and correct?
I do.
I tender the statements, Your Honour.
The first one will be Exhibit 2911. That's the one of the 8th of July. And the second one, Exhibit 2912.
Mr. Davies, you are presently employed as the Principal Legal Officer at the Department of Education and Training for the State of Queensland, is that right?
Yes,
And you were admitted, you are a barrister admitted to practice in Queensland,
yes,
and you have been since September 1998.
that's correct.
And as I understand it, prior to commencing your present role, you were a legal officer at the Office of the Director of Public Prosecutions,
Yes,
and you were in that position from August 1999 until August 2003.
yes,
And was it in that capacity that you came to handle the prosecution against the person known in these proceedings as BCH for offences in relation to the abuse of his daughter BCG?
yes.
Can you explain when in the proceedings, in the criminal proceedings, you became involved?
I was a case lawyer in the Office of the Director of Public Prosecutions. I worked in what was known then as the Committals Work Group in Brisbane. The Committals Work Group handled matters conducted, committals matters conducted in the Brisbane Magistrates Court. And I took over a particular cipher within the Committals Work Group. The cipher was known as CPA, which is a designation they give to a particular position. The lawyer before me in that position was Belinda Merrin, who's now a prosecutor. I took over her files, and one of those files was the one involving the people you've mentioned. And at that point in time, the proceeding was a part-heard committal. I think 2 days had already been heard in the matter, and I had about 1 day to go to conduct the committal. And that's really the context in which I came into contact with the matter.
And thereafter, did you have the conduct of the matter in its preparation for trial in the district court?
Yes.
And
sorry.
You finish?
Which entailed simply preparing a précis, which is described as a schedule of facts in the material for the prosecutor in preparing the indictment and attending to the instructions for the presentation of the indictment.
So is it the case you didn't personally prosecute the matter?
No.
Now, were you involved in the capacity you've described right through the case until ultimately conviction and sentence?
No. I was involved from memory. Really, the way it worked in the Office of DPP was you would, in terms of being a preparation officer, you would be responsible for a file you'd have core responsibility for a file until the indictment was presented. And then, in effect, the file would move then, would sit in your cupboard until it was allocated to a prosecutor, and then the prosecutor would effectively take carriage of the matter. They'd have a clerk that would assist them from the office, and then they would mainly rely upon that clerk and police officers until the matter was resolved. They'd only come back to the case lawyer, really, if there was something specifically they wanted the case lawyer to do. And I don't recall, for example, in the remaining time that I worked at the Office of the Director of Public Prosecutions, anyone coming back to me specifically about this matter, except, I think, to advise me of the outcome of a voir dire in relation to the first trial.
And what were you advised in that regard?
It was in relation to the admissibility of some inculpatory statements made by the accused. I'd formed a view that we might have some difficulty in relation to that, and I was advised subsequently that they'd been excluded on voir dire. Well, that's what I recall anyway.
Now, I understand from other evidence that there were 3 trials. The first resulted in a hung jury, the second a mistrial, and then the third a conviction on a number of counts. Is it the case that those outcomes were not reported to you over time?
No.
Now, the schedule of facts that you've spoken of, I don't know, do you have a copy of it with you by any chance?
I do.
Right, and we have it here. It's at Tender Bundle tab 37. In the form in which you have it, Mr. Davies, does it have a ringtail reference in the top right-hand corner?
It does.
Can you identify the reference of the document you're looking at?
It says QLD full stop 0068 full stop 001 full stop 1267.
Right. And there's a statement in that schedule of facts in capital letters in the middle column which says a crucial factor in this trial is the social environment created by the congregation of Jehovah's Witnesses, which has strongly influenced the behaviour of the defendant and all witnesses. Did you cause that statement to be recorded there?
Yes.
Why did you write that, Mr. Davies?
I had done a lot of preparation of offence matters involving sexual abuse of children, but this matter stuck out for me because I really had no exposure to matters involving the Jehovah's Witnesses. And when I read the material, conducted the last day of the committal, had spoken to the complainant, I think on more than one occasion, I formed the view that it was important that whoever subsequently had the file after I'd done the initial preparation work should instantly know that there was a context that underpinned the whole case. And I think perhaps I was just naive and that I had no understanding of the Jehovah's and how they approach these type of matters. To be frank with you, I'd assumed that any adult who had heard the type of complaints that the victim in this case mentioned would instantly go to the police. So really what I was doing by putting that on the schedule was just making sure that people were alerted to the fact that this was not a run-of-the-mill type of matter.
Beyond what you've explained with regard to going to the police, is there anything you were referring to in saying the influence and behaviour of the Jehovah's Witness faith?
Yes. It also, I think, covered off two other matters, in my thinking at least. One was the time frame, an explanation for the time frame between the allegations first being made by the complainant and then subsequently coming to the attention of the police, which was a period of some years. Just being in working in the Office of the Director of Public Prosecutions, you become aware that it's not uncommon for defence counsel, particularly in so-called historical sex abuse cases, to raise delay as almost a form of impeachment of the complainant. So that part of my thinking there was that this would be partially to explain, when you looked at the evidence that the complainant gave, her faith was a significant explanation for why it took so long for her to go to the police. Secondly, it related to the circumstances in which the accused made the inculpatory statements I referred to earlier, which was something I'd never encountered before. I considered highly unusual, and I considered that it would have an impact on the admissibility of those statements.
And do you recall what those circumstances were?
In terms of the inculpatory statements?
Yeah, the circumstances of the inculpatory statements.
The circumstances were that he went before a couple of committees of the Jehovah's Witnesses and had allegations put to him in front of a panel of elders, and he gave a response and they made findings. That was one aspect of it. It was kind of like a court proceeding in a way. The second aspect is that he, as part of his faith, as it was explained to me, I think possibly by the complainant, was that the more truthful he was at a certain point, the more chance later on he would get to be returned to the faith after being disfellowshipped. So two aspects, I suppose. One, he was encouraged or required to be truthful by the tenets of his faith, and the second was the more truthful and honest he was, the more chance that his punishment would end early.
So the one aspect you've identified is the delay that's caused by the handling of the matter internally to the church. Are there other consequences that you experienced in the preparation of this particular case that the handling of the matter internally to the church caused?
Sorry, I don't understand your question.
You've explained that because the matter was handled internally to the church and not reported to the police, there was a considerable delay before it was ultimately reported to the police. And you've explained,
that's correct.
You've explained the problem with the delay. Were there other difficulties that arose because of the manner in which the matter was handled internally to the church?
To my thinking, the only other major problem was in relation to the admissibility of the accused's statements. I think that there were the other problem that I didn't focus on as much because it didn't necessarily impact directly on the prosecution of the matter, but I acknowledge it, is that the way the complaints were handled internally by the church must have had a terrible impact on the complainant, and it led her complaints to be exposed to a very wide variety of people, more so than you would normally see in a sexual abuse case, where a young victim would speak to maybe one other person perhaps, and then the matter would end up in the hands of the police. In this particular case, the complainant was forced to go before at least 3 other members of the church. I think her mother was present, father was there. I'm not sure whether any other persons were there. That was only on the first occasion. On the second occasion, it was even a bigger panel. And these are at least on the first occasion, people who live in her local community. So undoubtedly she was subject to some gossip and innuendo that might have resulted from the revelation of those matters.
And whether in this case or more generally, do you conceive of there being potentially a difficulty with regard to the contamination of evidence?
Yes, that's true. Probably not as important in this case because of the age of the complainant and the relevant consistency of her statements over the years. I wouldn't have anticipated that as being specifically necessarily a problem in this case, but potentially in other cases, yes. It's true to say that the fewer people who discuss the matters directly with the complainant, the better, at least until it's in the hands of the police where they conduct a proper interview process with non-leading questions.
Now, I don't wish to put you on the spot on a legal question, Mr. Davies, but you may be aware that in New South Wales and Victoria there are statutory offences for the concealment of certain types of offences. But I understand that there's no such statutory offence in Queensland. Would that be right?
I understand that the relevant law, which would have been misprision of felony, ceased to be in operation in Queensland many years before I became a prosecutor. I think, from memory, possibly in the 80s.
1985, my research tells me, Mr. Davies.
There you go. That was only an educated guess on my part. But that really meant that you didn't have the same, I suppose, prosecutorial influence over people in terms of them reporting offences. So technically I don't think that the elders in this case committed any offence at the time by simply failing to report the matter. And, you know, in Queensland there still isn't a general offence of failing to report these type of matters, except in limited circumstances where you might be a mandated reporter in a particular professional occupation, such as teachers, doctors, police officers, child safety officers, etc. I've done a lot of work on that type of stuff in my capacity as a lawyer for the Education Department.
Mr. Davies, do you know the motivation for legislating to do away with the misprision law?
Look, no, I don't. The only reason I know about it at all is because I've had to do research on the issue in terms of my current employment to see what the laws were and how they affected departmental staff. And I had access, I think, to an Australian Law Reform Commission report that had some background research. And all I needed to know was it didn't exist anymore and there wasn't anything else to replace it.
Tell me, you may not know the answer to this off the top of your head, but is a Sunday school teacher a mandatory reporter under your legislation? Or would they be?
Very unlikely, because it would only apply if they were a registered teacher.
They've got to be registered.
You have to be a registered teacher.
Right.
Part of that, I mean, I don't wish to say I'm an expert on the matter at all, but that was a limitation that was imposed in the adoption of the Carmody report that occurred in Queensland a couple of years ago into child protection, and a lot of thinking was done about how you would define specifically the people that were going to be caught. And I was part of the discussions, I'll admit, and I think coming up, identifying people as registered teachers was just the simplest way.
Right. And I take it clergy weren't included?
I don't know. I don't think so.
No, that'll run you into other problems, yeah.
And you must understand that the mandatory reporting provisions in Queensland relate to child harm, so it's a much broader spectrum of matters than simply sexual abuse. If you look at the Education General Provisions Act, for example, in Queensland, which I have a lot to do with, you will see that there is a specific reporting provision, mandatory reporting provision, on school staff in relation to any sexual abuse. And that was amended only a couple of years ago in respect of a report authored by Dr. Ben Matthews from the Queensland Griffith University, I think, or QUT. I think you'll forgive me, I think it's QUT, where he had examined the nature of the mandatory reporting provisions in Queensland, and we changed them. It used to be you only had to report the sexual abuse committed by another teacher. Now it's broader.
So if it's happening in the home, it has to be reported if the teacher knows about it?
In the course of their duties, yes.
Right.
But there is no criminal offence related to the non-reporting in the Child Protection Act, area, it's not an offence. The only comeback, I suppose, you have against a person who's a mandatory reporter who doesn't report is really an administrative one, such as discipline.
So it's not an offence not to report?
Not under the Child Protection Act, no. There's an obligation, but it's not an offence. Unless you... I haven't explored the question of whether there's a provision in the Queensland Criminal Code that applies in relation to people who have a duty to do something, and if they fail to do it, there's a default term of imprisonment that applies. So I don't recall specifically whether or not that has been ameliorated in terms of that particular obligation.
It's odd to have an obligation without a sanction, but...
Well, I think as I said, I'm not speaking on behalf of the State of Queensland in relation to this, but I would say that the thinking there really was because the Carmody report was trying to triage the number of reports that were coming into the child safety system. About 80% of matters reported were not acted on. They didn't reach the thresholds necessary for child protection statutory action, and they were effectively clogging up the system and wasting time and taking resources away from what considered the core concerns, really the sexual abuse and severe other abuse matters. So I think the thinking probably was that if we make it an offence provision, that's going to encourage people to report everything, rather than give effect to the policy aim of the reforms, which was to only get the most important stuff reported.
Well, you could do that by making it an offence provision in relation to the important matters, couldn't you?
Perhaps, yes.
Yeah. Yes, Mr. Stewart.
Mr. Davies, in your role in the prosecution service, did you have any involvement in other cases where there was some Jehovah's Witness element to it, relevant element?
Not that I recall.
Those are my questions, Your Honour.
Did anyone else have questions of Mr. Davies?
Yes, Your Honour.
Anyone else? No. No. Yes.
Thank you. My name is Coyne. I represent Dino Ali, Kevin Bowditch, Ron DeRoy and others in these proceedings. Mr.
I
Davies,
think you need to just identify they're elders of the Jehovah's Witness Church.
who are each elders in the Jehovah's Witness Church. Mr. Davies, you made a statement on the 8th of July 2015. Correct?
Yes?
That statement was about your dealings with members of the Jehovah's Witness Church as part of the prosecution of someone. Yes?
Yes?
Yes. In that, did that include Mr. Dino Ali? Did you deal with him?
I don't recall specifically. I did have access to the committal transcript.
Yes.
But I didn't check it specifically. I do recall that I led evidence from the elders, at least in relation to the first appeal matter, but I can't recall specifically who they were.
Do you recall which elders made statements in relation to this matter?
I recognise the names DeRoy, Ali, Bowditch. Those are the ones that stick in my memory.
Yes. As elders who made statements in relation to the prosecution.
That's correct.
Yes. You say in your statement that you did not have any difficulty in obtaining cooperation from witnesses I examined who were in the main lay representatives of Jehovah's Witness Church, correct?
Correct.
Would that include those three persons that I've named?
Yes.
Yes. You've said, I do not recall any reluctance or hesitation to assist me in obtaining records in question in relation to the proceedings.
Yes.
Yes. And you've also said, I do not recall feeling that they had been uncooperative or mendacious in any respect.
Yes.
And that's referring to the witnesses again.
That's correct.
And that would be the three named people before, Ali, DeRoy and Bowditch.
That would be inclusive of them. I don't recall any problem with any of the witnesses really in the matter that I dealt with.
And you requested statements for the prosecution, which they made.
Well, I didn't request them. They would have been prepared and obtained by the police.
Yes.
They would have been part of the prosecution brief before I ever obtained the matter. But I may have spoken to them on the phone before the hearing. If, for example, the matter was going to be full evidence,
Yes.
that's just my memory of it, I might have wanted to speak to them and take them through their evidence beforehand, effectively, conferencing them, and then I would have led their evidence in court. But that's probably the only contact I would have had with those particular witnesses.
Yes. If you had to characterise their statements from a prosecution standpoint, would it be correct to say that they were corroborative of the complaint?
I think so.
Would you also say that they contained alleged admissions of the accused?
I think if they didn't specifically contain them, they certainly referred to them.
Yes.
Because I think there were, from memory, there were admissions outlined in other documents that we obtained directly from the Watchtower Society, I think, from memory.
Yeah.
And there was a solicitor I spoke to, and I had to organise a subpoena for documents.
Yes. So each of those statements of DeRoy, Bowditch, Ali, were all in support of the prosecution of the accused.
Yes.
Thank you.
Yes, no other questions? Mr Stewart?
Nothing further, Your Honour, for Mr Davies.
Thank you, Mr Davies. Thank you. That concludes your evidence and you're formally excused.
Thank you.
Might I also be excused, Your Honour?
Oh, yes, certainly. I'm sorry, Mr McMillan.
The witness whom I would call next ordinarily would take some time, and given that we've committed to have the expert witness of the Watchtower Society on Friday, it means that that witness's evidence would hang over at least tomorrow and part of
Well, I
Friday.
think we're travelling well in accordance with our schedule, so we're not troubled by adjourning now, if that's what you're asking.
Well, that is what I'm suggesting.
Okay, all right. We'll adjourn until 10 o'clock in the morning.
Friday.
Oh, sorry, 10 o'clock Friday morning. Yeah.